This is the Grand Traverse County Board of Commissioners study session for Wednesday, February 27th, 8 a.m. We'll start with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Bonnie, roll call, please.
LaPointe,
Present.
Klaus,
Here.
Wheelock, Jewett,
Here.
Hunley,
Here.
Kofia, here, Henschel.
Here. Next item on the agenda is first public comment. Please read the rules.
Any person shall be permitted to address a meeting of the Board of Commissioners which is required to be open to the public under the provision of the Michigan Open Meetings Act. Public comment shall be carried out in accordance with the following board rules and procedures. Any person wishing to address the board shall state his or her name and address. No person shall be allowed to speak more than once on the same matter, excluding time needed to answer commissioners' questions, if any. The chairperson shall control the amount of time each person shall be allowed to speak, which shall not exceed 3 minutes. The chairperson may, at his or her discretion, extend the amount of time any person is allowed to speak. Public comment will be solicited during the 2 public comment periods noted in Rule 5.4 Order of Business. However, public comment will generally be received at any time during the meeting regarding a specific topic currently under discussion by the board. Members of the public wishing to comment should raise their hand or pass a note to the clerk in order to be recognized and shall not address the board until called upon by the chairperson. Please be respectful and refrain from personal or political attacks.
Okay, do we have anyone for public comment this morning? Please step up, say your name and where you're from.
Ann Rogers, 1236 Peninsula Drive. You are what's termed public servants, and the public gets to comment once in a while. The idea, though, that 4 of you chose to have the meetings at 8 a.m. is really cutting out a lot of the public. We are coming in the mornings like this when the roads are terrible because a lot of people can't. I've had people say, please say this for me, or please comment on that, because they can't make it this early. And with the roads like they are, I'm surprised any of you who live out have made it. It's really an affront to the public in your public office. Thank you.
Just step right up. Morning.
Morning. John Dispelder, Traverse City. I'll be brief, and it's about why you're here today. First of all, I want to thank you all for being here. Maybe Sonny will make it. I know he's got a long ride on some bad roads. But this is a worthwhile subject. I don't think anybody would say that there's enough trust in government, and I think that's what this is all about. I do think that through your deliberations, the most important thing to me is going to be what we hear publicly from you, what you say about your beliefs and how you plan to conduct yourselves. And then we want to see that you do conduct yourselves in that way. And also, it has not just to do with this commission, but it has to do with the entire county government. It's bigger than just all of us in this room. So thank you for doing this. I appreciate it.
Thank you. Anybody else for public comment? Just step right up.
Donna Hornberger, Peninsula Township. My husband thought I was crazy coming in this morning in this weather. My subdivision had not been plowed out. The roads are icy. 8 o'clock in the morning is a terrible time to have this meeting in the winter.
Anyone else for public comment this morning? Seeing none, we'll move on with our agenda. This is a study session. We will not be taking any board votes on county business in this. This is merely to have an opportunity for the board to discuss topics. We've been provided a packet that's going to be our topics of discussion, and this meeting was requested by Commissioner Kafia and I believe Hundley and Wheelock together. So I will turn the floor over to those folks and take it from here.
Sure. Good morning, everybody. Thank you for being here. So this is something that I had initially suggested at our very first meeting, Mr. Chairman, when you asked us all if we had study session topics that we'd like to learn more about. And it was really inspired by several things, but honestly, the controversy that sort of landed on our lap the moment 5 of us sat down at these desks with the question of the Tattle appointment, and conflict of interest became a pretty hot topic right out the gate. And also, frankly, from a citizen perspective, coming in as a first-time elected official, I've been aware over the years of multiple situations. I was trying to do some math last night, but over the last 10 years, it's come up at least once or twice every 2 years, so every term or so, questions about either personal or financial dealings of the county commission and whether there was a conflict of interest and how that would be handled. And as I was reviewing again our counsel's memo, where he spoke a lot about Judge Rogers setting sort of a precedent. I don't know if I'm using the right word, about appearance of impropriety being used to actually negate local elected officials' decisions. And those were financial decisions, not personal relationships, but that was an early lesson on this topic. It just really inspired me to kind of look a little deeper at what we do have on the books, what is our current policy, to recognize that currently we don't, as part of our orientation, even review it, even though we review like FOIA and the Open Meetings Act, and it feels like a pretty prescient topic. I've also looked around at other communities, how they are handling the question of ethics and conflict of interest when it comes to a body that's entrusted with the public's money, basically, $40 million budget. And, for example, Washtenaw and Emmett counties, I found, are reacting to controversy and now addressing the question of conflict of interest and trying to install strong policies that inspire public trust. Washtenaw was interesting because they had a commissioner who actually stepped down in order to run for a lucrative county position, and that became very controversial. And as a result, they sort of reacted and created a policy with some teeth in it. And then Emmett has had some similar questions. I think it was a relative applied for, it was either the administrator or some such, and that became very controversial in the community. But I look at our current policy, and I've already said this, I read it as not actually even really applying to commissioners, certainly in its any sort of enforcement, because the only remedy is termination, which of course we can't vote to terminate each other, and I have found that there are other counties that have various levels of action that the board can take to try to either restore or reassure public trust when there has been a controversy around conflict of interest. So Antrim County, Emmett, Leelanau, they have a training. They have documents that they ask their incoming commissioners to sign and say that they understand. My thought was, let's take a look at this, particularly with the very early question about conflict of interest and what I perceive to be a really high bar that has been set. This board was comfortable negating a past board's appointment based on the precedent from Judge Rogers saying there was an appearance of impropriety. So I want to understand this policy. I want to make sure that it is doing the work that it needs to do to serve public interest. And so that's why I asked for the study session, so that we could dig into it. And I appreciate the opportunity for us to just think about it, look at it, see what the examples are. And I appreciate that council has prepared the legal side of things to present to us. So that's what I have.
Okay.
And anyone else who wants to jump in?
My comments are, well, just as far as to echo, I suppose, what Betsy was saying, in the initial thing that hit us early on with the library board appointment, and as you'll recall, I was wrestling with, well, my wife is, I mean, she's a page in the kids' room at the Woodmere branch. And so then even wrestling with, you know, does that rise to the level of a conflict of interest, and just working through those issues, and I felt like I was working through those issues on the spot and hadn't really had a chance to get my head around, you know, what that looked like in a public official setting. So I appreciate you guys being here today and getting a chance to look through these. And I got some comments on the packet as we go through it, and that's all. Just thanks.
All right, where do you want to go from here?
Mr. Chairman, I'd just like to ask that if we can we try and wrap this up by 10 o'clock, just because I have other committee meetings that I'm assigned to today, that are going on today. I don't know if that's a possibility or not, but if we can wrap it up by 10 o'clock, I would try to appreciate that.
We will make an effort.
Okay.
All right, do we want to go to staff for presentations now?
Yeah, so similar to, again, like we did with the pension piece, I was encouraged to submit sort of questions and ask council and staff to have an opportunity to prepare some sort of a presentation for us. And so that is hopefully what happens
Turn it
next.
over to staff.
So what you have in front of you, Kit is going to talk in large part to this, but what we did is prepare this packet with the current Code of Ethics policy, the current opinion of now Judge Cooney, then Prosecutor Cooney, in terms of what the obligations of the board is or are. Commissioner Coffey did present to us the rest of the items in this, and Kit and I have met with Commissioner Coffey and discussed this as well and brainstormed a little bit. Kit did the lion's share of this work and will present from this point forward.
All set?
All set?
All set. Morning.
Morning.
Good morning, Kip.
So I'll present today on a code of ethics, whether that's as a policy or an ordinance. But to start, just wanted to talk a little bit about why. Why would we have one? We actually have one already. Why would we even have that, and why have other counties chosen to do that? The first reason is it's been defined as aspirational in several of the documents that you were provided to review. So that's a message to the public. That's setting our ideals in writing, saying this is what we want to live up to. This is what we want to guarantee to the public when we're working with their money and their trust. And then it serves from that point as a reference point for the standards that we want to keep and we can try to uphold among each other for the public. It also can function as deterrence. If there is an enforcement mechanism, it can work to try to deter people from even working on the borderlines of unethical conduct. Setting those boundaries, guiding our goals, so that no one wants to be even accused of violating a code of ethics or engaging in unethical conduct. So it can serve as a deterrence, and lastly, if there's an enforcement provision, it can also function to sanction, reprimand, or as the options actually work out, there can even be criminal or civil penalties. But what that does is this shows that you are serious about this behavior and serious about not allowing unethical conduct. The current parameters is something that I was asked to speak to. So we do have a code of ethics policy, and at least by its writing, it does attempt to apply to you. It says county employees and officials. You are officials, but as you saw in Judge Cooney's memorandum, and really the best reading of the law would be that it is not actually applicable to you. You haven't adopted a resolution saying this is applicable to us. You haven't signed anything, as far as I'm aware, saying I agree to be bound by this. And it does actually have an enforcement provision. What it says is that it's up to and including termination. And as you are all well aware, that does not apply to you. Removal does not apply to you, except in certain circumstances, which I'll get to a little bit later. So we have a code of ethics policy, which you could apply to yourselves, you could agree to be bound by it. But as of right now, I don't see anything that's telling me that you are, in fact, bound by this code of ethics policy. What we also have are Robert's Rules of Order, and this came up last December, and then again in what Robert's Rules says about conflicts of interest. This is applicable to this board because of Board Rule 12.1, which says that Robert's Rules guide in situations where there's no specific board rule. Robert's Rule says that no member should vote on a question if they have a direct personal or pecuniary interest, which is not common to other members. So it's actually rather broad, but also leaves room for interpretation. Is this something that's direct? Is there a personal interest in this? Some situations that will be quite easy to decipher. Does somebody have a personal interest if they're voting on something for a family member? That's actually quite easy. But when you get into pecuniary or financial interests, whether something is direct or indirect is actually quite difficult to determine. There's existing state law which talks about ethics and conflict of interest. Examples would be these two laws. We have public servants who contract with entities they serve, and that's something that's came up this year with Commissioner Wheelock. Requires that he recuse himself from a vote on it, requires a disclosure, and then a later vote, and then a 2/3 majority. So that's something you are familiar with, and if you ever have questions with, it's very well defined in that statute. There's also the incompatibility, meaning you can't supervise yourself, essentially. You wouldn't be able to serve, for example, as a prosecutor, because you have funding control over the prosecutor. So it's an incompatible office that goes to ethics, and you can't supervise yourself. Criminal laws I put on there are set in stone, and they are really just a code of ethics for the public at large. Those also obviously apply to you. None of them that I would say specifically come up here, so I didn't include any by themselves, but that is a code of ethics for the public at large. That is in contrast to several other areas where there are specific code of conflict of interest and code of ethics policies. So, for example, state legislators, there are laws that govern their conflict of interest and when they have to recuse themselves. All state executive branch officials are governed by strict conflict of interest laws. There's a code of judicial conduct. There's rules of professional conduct for lawyers. Many other professions are guided by conflict of interest rules. But there are not for county commissions. It's something that apparently has been considered in the past, but nothing has ever come of it. So at this point, we're left with the current parameters and then potentially in the future, something more. Judge Rogers' decisions out of the 13th Circuit case law has come up already today. I'll talk briefly about both of those. They are rather lengthy decisions. The first of them was in 1990. It was a group of Garfield residents that was organized into a nonprofit corporation, as well as the owner of the Cherryland Mall and a group of interested an environmental nonprofit that was also interested in the outcome. And it concerned the building of the Grand Traverse Mall. The Zoning Board of Appeals for Garfield Township had approved the development, as well as several permits for the Grand Traverse Mall, and also a special land use permit, or a variance. It was a variance in this case, from the zoning regulations. There's a 5-member Zoning Board of Appeals, and 2 of those 5 members had actually sold land to the group that sold the land to the Grand Traverse Mall. So those 2 members, the idea of the plaintiffs, Garfield Neighborhood Watch, was that they had sold the land at an inflated value because the person who was buying it knew they could sell it at a large price to the developer of the Grand Traverse Mall. So that was the idea, is that there was a conflict of interest among those 2 Zoning Board of Appeals members, since in theory they may have gained additional money because they knew or may have made a promise that they were going to approve this development of the Grand Traverse Mall. So that was the legal issue, is whether there was that conflict of interest and whether that would invalidate the Zoning Board of Appeals' decision to approve this project, to grant the variance, and to grant all the relevant permits. When Judge Rogers analyzed it, he found that there was not a conflict of interest among those two Zoning Board of Appeals members because they had sold to the prior owner. So they hadn't actually interacted with the developer. So their interaction, their sale, was going through regardless of whether Grand Traverse Mall's permits were approved. But he went further than that, and that's where the appearance of impropriety doctrine came in. And this is not an established doctrine in Michigan. It is now in our circuit because of these two decisions. But what he looked at was case law which did mention it, which talked about how the appearance of impropriety is damaging to the public's trust in government action, and how that is something that should be considered and should be given effect by policymakers. Looked at law in other states where there was established doctrine on this. Connecticut and Oregon, I believe, were two of them. And then he also looked at the Michigan Constitution, which guarantees fairness to people in their interactions with their government, guarantees due process and when their life, liberty, or property is at stake. And so he said that this doctrine, it's in other states, it's been mentioned in Michigan, and it comports with these constitutional guarantees of fairness towards people. So he did establish that as something in Michigan, at least in our circuit. And so then applied it to the facts of the case. Well, before he applied it to the facts of the case, he talked a little bit about the contours of what this means. And it is buried in this, I think it's a 63-page decision. But buried in it, he does talk about some of the boundaries of it. Is it just anybody who thinks that there's something improper going on? No. So there are contours to it. It's not speculative. There have to be actual facts that are leading to this appearance. His discussion of this was actually very fact-intensive and looked at true facts that were established by documents or by the statements of the people themselves. So it's not speculative, and it's not remote ties. That was another thing that he saw quite clearly in the case law of other states. So he was looking to actual facts which reasonably call into question the impartiality of the decision. And that does define the contours more. It still leaves it open to interpretation and speculation, prediction for whether something would appear to be an appearance of impropriety that could potentially invalidate a township or county board's decision. So the outcome in this case was that the two votes of the people who had sold land to the seller to the Grand Traverse Mall were disqualified. So there hadn't actually been a conflict of interest, but he did believe, and said the record supported, that there had been an appearance of impropriety. And they are very distinct beasts. A conflict of interest goes to the actual reliability of the outcome, the actual impartiality of the outcome, which is important for some reasons, but the appearance of impropriety is important for other reasons, distinct reasons, meaning the public's trust in the impartiality of their government's decisions. So those two votes were disqualified because of the appearance that they had a stake in the outcome, that it was not impartial, that they may have been given a gift in an inflated value of their land, or that they may have made promises regarding an approval. So that was the appearance of what had happened. So their two votes were disqualified, but the resolutions to approve the project, to grant the variance, and to approve the permits still stood because it was a 5-member board. The votes had been unanimous, so there were still 3 remaining votes, which was a quorum and a majority. So in that case, there was actually no effect to this. But Judge Rogers was clear that it could have been different if those two had been attempting to sway the other three. If they'd been arguing vociferously or really pushing for the other three to vote in line, that there could have actually been a problem. But there was no evidence in the transcripts of the actual hearings that the two disqualified members had actually tried to sway the other three. So fast forward 11 years, and you've got another nonprofit group of local residents. This is the Elmwood Citizens for Sensible Growth, nonprofit group of residents that are challenging the approval of a condominium development in Elmwood Township and a special land use permit that was granted in order to have that housing development built. The approval passed at the Planning Commission in Elmwood Township by a 4-3 vote, so a close vote. And one of those members, while the process had been ongoing, so after the developer has started the process of getting permits for this development, one of the people on the Planning Commission had bought adjacent land well below the list price of the adjacent land. So the idea there was that the land was going to increase in value if this housing development went in. Increase in value as maybe a further housing development or a parking lot or recreation area for the housing development. So one of the members of the Planning Commission had actually purchased the property for well below the list price, well below the appraised value, while the process was ongoing. So the question was it a gift? Had the developer given the person the property at a lesser value? Or potentially had there been a promise from this member of the Planning Commission to help smooth the way for permits and a land use variance? That commissioner, a member of the Planning Commission, had actually disclosed that they were purchasing land during it. They hadn't made a full disclosure. And then the Planning Commission and later the Township Board had actually said, thank you for telling us, we're okay with you continuing to participate and continuing to vote. Later, that was discussed and was determined that that actually doesn't have an effect. Just because your counterparts say they're okay with it doesn't necessarily mean that the public, that the appearance to the public is any less serious. But in that case, the commissioner's disclosure had only been partial as well, had just disclosed that he was in the process of purchasing property, not that he was getting it for a lesser price. The outcome of this was that the vote was invalidated. This person, judge found, should have recused himself because of the appearance of what was going on. It was unclear whether there was actually a conflict. What Judge Rogers said was that actually further development of the facts would have needed to be done. Was there a gift? Was there a promise? Was the appraised value too high? Maybe this person actually bought it at the fair market value. So unknown whether there was actually a conflict of interest, but the appearance was serious and reasonable enough that the public's trust in the impartiality of the decision meant that this commissioner should have recused himself. Because it was a 4-3 vote, that meant that there was a 3-3 tie and there was no effective action. In addition, that commissioner had been very vocal in getting the project approved, so that further created concerns about the impartiality of the decision. What effect this had on the doctrine of the appearance of impropriety in our circuit is that it cements the existence of it. We've got 2 cases now, 11 years apart, with nothing contrary in our circuit or at the Court of Appeals level. So that does govern our actions here. It cements that an actual conflict is not critical, that there doesn't actually have to be a conflict of interest, but merely a reasonable appearance based on actual facts could potentially invalidate a decision. It also shows that a legislator can't disclose their way out of an appearance. That commissioner had attempted to do that in the Elmwood Township case, but that was not given effect. And in this case as well, there had been an in-depth look at the facts. So it wasn't just, this looks bad to the hypothetical member of the public, so therefore it's invalidated, but it was a very fact-sensitive inquiry. It was looking at actual facts, looking at the actual purchase price of the property, looking at the dates when it was purchased, looking at the dates when this commissioner was advocating for the special land use permit and was advocating for the approval of the development. So looking at actual facts. In this case, some of the facts, in both of these cases, the actual facts were not difficult to establish. Purchase records, there were transcripts of the hearings, and there were numerous statements. So there was really no question that there was a direct, or appeared to be a direct personal and financial stake in the outcome. So in those cases, it was actually very easy, but the court, again, was looking at actual facts which truly appear problematic and then tainted the entire proceeding. There are several limitations to each of these current parameters that we have, those 4 current parameters. The Code of Ethics doesn't really apply to you. You can take a resolution, you could adopt a resolution which applies it to you, or you could indicate your acceptance to being bound by it. There's the applicability. It also is not very definite on what a conflict of interest is, what a commissioner would be prohibited from doing, so what actually conflicts improper behavior, what actually comprises creating an appearance. And then the procedure is almost entirely absent from that document. So it says discipline can include up to termination. That is deficient. If you were to be stripped of some sort of committee position, or stripped of your ability to travel, or even reprimanded, you do have the constitutional right in Michigan to fair and just treatment by legislative processes and hearings. And that right includes procedure that you're aware of so that you can defend yourself and not be stripped of some right that you enjoy without due process procedure. So it's lacking in all 3 of those things: the applicability of it to you, the definition of what is actually prohibited, and then the procedure if you were to be actually held in violation of it. Robert's Rules of Order also say that no member can be compelled to refrain from voting. That came up in December with the past commission, that according to Robert's Rules of Order and our board rules, there's nothing in place to prohibit a person from voting when they are conflicted or whether there's an appearance of a conflict. Existing state law is limited, and because there's so few circumstances that are actually covered, there's the criminal law, but I'm not aware of anything even approaching something criminal happening here. So that is not sufficient. And then it only talks further about when a board member is contracting with Grand Traverse County and when there's incompatible public offices. So there's very, very little that's actually prohibited by existing state law and state statutes. The local case law is limited in the fact that it's reactive. So there's nothing that can be done proactively saying, hey, I think you shouldn't vote. And that reactivity is further limited by the fact that it requires a court decision to actually say anything about it. We can predict or speculate based on what a court would do based on the 2 cases that we have, but it's purely speculative on what a judge would decide. Judge Rogers isn't on the bench anymore. He retired. So we have new judges who would certainly find his decisions persuasive, but we don't have clear guidance. So it's reactive and it's speculative on what would actually happen. The existing state law as well is purely reactive, with the exception of the contracting with public entities, which prohibits voting for people who are contracting. So for the most part, the existing law is either inapplicable or provides no recourse or is purely reactive. But there are options for changing that if the court, or if the board.
Hey, sorry, Kit.
Yeah.
Just stop you for a second. On the Roberts Rules of Order one, we lean on Roberts a lot, and it's generally pretty good. And the rules make an affirmative statement that no member can be compelled to refrain. Do you know what the thinking there was, or like?
I know one circumstance that they cite in there is that members shouldn't be automatically compelled because in some circumstances a vote is necessary, whether it's for a quorum, whether it's for a majority of members elected and serving.
Right.
I could also imagine the concern that minorities would be subjected to it unfairly. Minority members of a
Yeah, right.
of a
Right.
group. And then they do also reference the specific situation where if the 7 of you wanted to have a banquet and you wanted to have food provided for it, you would all be getting a free meal out of it, so you're conflicted in that sense,
Okay.
but then you'd never be able to have a banquet.
Right.
So they do mention that specific concern about conflicts of interest and prohibiting members from voting if there's a conflict of interest. Other than that specific concern, though, I guess it would be my guess that the reasons are concern for minorities, quorums, and majorities.
Okay. Thank you.
So there are options if you do want to go further. The first option, though, not saying this glibly or flippantly, but the first option is to do nothing. So we did recently have a pretty significant conflict of interest issue come up, and that was the impetus for us being here today. But we did come out of that, or we, meaning the county, relatively unscathed. There was no financial judgment that ended up being ordered against the county. There was a hit to the reputation of the county, but no monetary loss other than my salary for the few hours I spent in court related to that lawsuit. Just going beyond nothing, you could also adopt a resolution giving effect to the county's Code of Ethics policy, which would indicate assent to be bound by that Code of Ethics policy, if a resolution were passed adopting that as effective on the Board of Commissioners. In the packet, though, the majority of it was comprised of a revised Code of Ethics policy based on 2 examples, and then an ethics ordinance. So these are 2 further options that you do have. Yes?
Ask a question. You said one of the options is ask that everybody agree or sign that they'll comply with the Code of Ethics. Are you talking all employees or just the board? Are you talking all elected officers?
That's a good question. What I'm presenting on mostly today is for the Board of Commissioners to be bound. So county employees are bound by the Code of Ethics policy. We've agreed to be bound by it. But
You
the Board of
signed
Commission-
something? All the employees have signed a document?
I believe we did when we were hired. Yep, and it is applicable to the employees. So,
Yeah, so I can speak on that, Commissioner Point. So when an employee is hired and they start, one of the things they're given is the employee handbook that includes all the policies, including the ethics policy. And they have to sign an acknowledgement saying they received this, they read through this. I don't have it in front of me, but it might even say something like, your failure to follow these policies could result up to termination.
Kit, the problem that I see is our ethics policy truly is not real distinct. So, trying to figure out how it applies, not only to commissioners, but even to employees, I don't think we're really well defined in a lot of those categories. Would that be your interpretation, or is it just the way I'm
Yes.
reading it?
yep. No, you're absolutely
The
correct.
problem is, I I hate it when we have policies and we say we have these policies and we're going to enforce these policies on whoever, but there's truly no definition of what creates the conflict and what we're going to do about it when that conflict occurs. You know, and I think this ethics policy, like unfortunately, like some of our other policies, really do not well define what is a violation of this policy and what is the results of that specific violation.
People often express frustration about legalese and lawyers taking 10 pages to say what one sentence could do. And I'm not saying there's not a problem, but there is very good reason for that, because you need to precisely define terms. You need to provide proper protections for people, and that's all the procedure that gets put in place for, okay, if we're going to sanction somebody for a violation of this policy, here's the protections that they have, and here's the procedure we're going to follow to sanction them so that they can properly defend themselves against being sanctioned. So that's frequently why there is so much legalese or 10 pages, and you're absolutely right with the current Code of Ethics policy. There's not definition of what a violation will be, or conversely, what a violation is not, and what is permissible. And that's something you see in the Antrim and Emmett codes of ethics. You do see clear definitions, especially on gifts. What are permissible gifts to county commissioners and what are impermissible? So I'll get to that in a moment.
Unfortunately, we all sit here and we think that an ethics policy is common sense, but somehow or another common sense doesn't seem to be too common anymore. You know, it's just, you know, when you make the statement, you know, we have an ethics policy and you can't have a conflict of interest, I think, you know, in everybody's mind, they have in their mind, what is a conflict of interest? You know, whether this is the time or not to discuss it, you know, I'm in a situation where because of my doing business with the county on occasion, I get into conflict quite often. The results of that is because of the perceived conflict, there are many, many projects that I am very well capable to do that county departments do not contact me about to even price because they can't wait 8 days for me to tell the county commissioner that county commission and then have to vote 2/3 before I can even vote. I've sat here and seen us pay 10-15% too much money for projects because I either didn't get the vote or didn't get the opportunity to bid, or the commissioners did not by 2/3 vote approve me doing the work.
Yeah.
And you know, we're in a situation right now. I sold $300 worth of steel to the Grand Traverse Sheriff's Department and Facilities Department, about 45 days ago. I acknowledged it to the Board of Commissioners. That bill has not yet been paid due to the fact that with an absentee, with Mr. LaPointe being absent and my not being able to vote, the Finance Department did not bring the bill to be paid last month because they wanted to make sure that there were 2/3 people here that would be able to vote.
That's a situation where we have absolutely no flexibility, as you know, because of the state statute. But with a Code of Ethics policy, there's a lot that's very open for if you do want to go there, with how exactly to word things and create the procedure to potentially avoid something like that, if that is something that you want to do. Wisdom of our state legislators in doing that, and absolutely no flexibility on it. What there is flexibility on,
And it doesn't even give us the flexibility in our purchasing policy to allow it up to a certain number of dollars. If it's a $5 job, I still have to submit to the Board of Commissioners 8 days before I do the work.
PowerPoint froze.
Sonny, have you ever not been paid? Has the board ever rejected some work for you?
No.
That's good.
Took over 90 days recently for a project, but other than that.
So one of the things that I was asked to do is talk about options for the board that have teeth, and that was the word that's been used. So, but looking at what we currently have, another thing you would want to consider is having a policy or ordinance that has greater definition, applicability, obviously, and enforcement terms, which are the teeth. So that could be a revised code of ethics policy that is applicable to the board and to the county employees. You also have the power to enact an ordinance on this subject. So I'll talk about those in turn. The Code of Ethics Policy, this is MCL 4611. This is the powers of the Board of Commissioners. You have the power to establish rules consistent with the Open Meetings Act for the manner of proceeding before the board. And that is where codes of ethics are adopted. Antrim and Emmett reference 4611 as far as establishing rules for procedure. Rules for procedure, manner of proceeding before the board. There are limitations to this. It cannot conflict with state law, and there's a large doctrine of law called preemption, which defines when something does conflict with state law. It's not specifically being opposite, but if the state has decided to act in an area, generally we can't also act in an area because the state has preempted us in that field. So an example of that is that we cannot remove somebody from office. You cannot vote even 6-1 to remove somebody from office. That's a power that rests solely with the governor. And then in any legislative hearing, legislative investigation or hearing, you have to provide fair and just treatment to the person who is before you. So whether that's a commissioner, a member of the public, a county employee, they have to be given fair and just treatment by the board. 2 examples were given to you in the packet. Those were Antrim and Emmett. They both proceed the same. They provide several prohibitions, and then they define those. And those are specifically defined prohibitions. It's not just can't have a conflict of interest and should avoid an appearance of a conflict of interest. So some examples of that in Antrim's policy were to not participate in an action for the Board of Commissioners. You actually remove yourself from the room in all deliberations. Antrim commissioners are prohibited from advocating personally before the Board of Commissioners. So if they were to recuse themselves, they're prohibited from coming up here and saying, hey, I was just sitting right there, but now I'm right here asking you to approve a contract for my company. That would not be permissible in Antrim either. There is a large and long definition regarding gifts, what type of gifts are permissible, what type of gifts are prohibited.
Excuse me. So if we were in Antrim right now, Sonny would not be allowed to say what he just said about sometimes the county pays 10 or 15% more than they should because he's not able to do the work. That would be...
I couldn't
Right.
say it at such a time as that job was being discussed.
I don't think I can give an answer right now. And then both of the prohibitions, both of the county policies actually prohibit using public resources for private gain. Something that would seem rather self-explanatory. If you want a building permit, that you're not going to go in on your public time and ask for it for free. That would be using the county resources of the building official for personal gain. So those are all spelled out in clear terms as clear prohibitions. The county then talks about conflicts of interest and voting of commission members and says that if there is reason to believe, so rather broad, a potential conflict of interest exists, that board member must disclose that to the entire board. They may still vote, however, if they also provide an explanation of why they believe that they can be impartial and act in the public's interest. The county chair, however, can order that person to recuse themselves, and that can be overruled by a majority vote among the board at large. That's how they've dealt with it. And Emmett took, and then there are enforcement provisions as well. The commissioner can be admonished, they can be requested to resign. I would imagine that was worded specifically how it was, because they can't be forced to resign, but they can be requested to resign. The enforcement then says that civil action may be taken if possible, and that also it can be referred to the prosecutor's office for potential criminal enforcement. Yeah, it's good to spell it out, but any matter could theoretically be referred to the prosecutor's office.
So Kit, back one step, the piece where the county commission can reprimand, right, or request recusal. I mean, my read of that is the body as a whole trying to shore up public trust when there is a question. Is that just to say, like, look, we do feel that there's a conflict here, and taking public steps to say we're not just looking the other way while this is happening?
That would absolutely be one effect of it. There's also the hopeful effect that the person reconsiders based on the fact that four of their colleagues think that they shouldn't vote. So yeah, that's certainly one
And those are
positive.
concrete mechanisms that are in place for the board to look to when something were to come up, as opposed to, like I said, again, when I read our current policy, there's really not anything
Well, I think
that's
you
in
actually,
procedure that the county board can say, well, what are our options here? What can we do to address this?
I think you actually could probably do that right now. You could vote to request somebody to recuse themselves. I don't see anything that would prohibit you from doing that
Right.
as the board rules stand right now.
But there's no procedure in place, is
There's
my
not.
point.
Nope. It's
And
not
that
spelled
vote is
out.
not binding.
Sorry?
And that vote is not binding.
No. No, it's not.
Well, Kit, if the county chair was to order someone to recuse themselves, that's not binding either because it's
Right.
against state law, right? State law says they cannot be, I mean, they were elected to represent people, and we can't take away what the people have given them the right to do.
That is a strong moral argument, but I did look, because that was something that initially concerned me, of, in effect, disenfranchising 1/7 of the county constituents. But, so there are a couple things that weighed on, or seemed important to me. So for example, there's no requirement that there be 7 of you. The county could say, we're gonna have 6, we're gonna have 5, we're gonna have 15 county commissioners.
That's set by a board of canvassers.
No, by the apportionment committee.
Yeah.
The
So if we wanted
districting.
more, we could probably get more. And there's no state law that
We were recently cut
prohibits.
from 9 commissioners to 7.
Right, after a census, then the county clerk, the prosecutor, the treasurer, the Republican chair, and the Democratic chair meet and can redraw the lines and determine if they want more than 7, less than 7.
But that's not a decision the board of commissioners can make.
No.
No, there are limits. I think we can't have more than 25 or something. Chris might actually know the answer to this, but there are limits. You could have a lot more than you currently have.
And then one
We
other
could have
just
more.
related question I'm not sure of, and it's tangentially related, is whether county commissioners are considered to only represent their specific district, or because the decisions we make impact the entire county, if we are in fact voting to represent our whole county. So is there a difference between, like, are there counties in Michigan that are at-large commissioners versus district-specific? Bonnie, do you know?
I don't know that.
I don't know either.
Okay.
So, ordering recusal was something that originally did concern me, but I did not find anything that prohibits ordering recusal. And there are certainly concerns, there are policy concerns with that. Those are for you to weigh on whether that's something you actually want to include. But at least based on my review and what I've seen, I think that it is actually permissible to order recusal. It would conflict with Robert's rules, but our board rules can conflict with Robert's rules. That's perfectly fine. Apparently, Antrim felt comfortable with it. So there are several steps that can be taken: the admonishment, the censure, request to resign, and then there's that recusal mechanism either from the county chair but that can be overruled by a majority vote. In Emmett, they also laid out several specific prohibitions. Again, there's the prohibited gifts and the permissible gifts. They also included respecting the confidentiality of information that you learn as county commissioners, not using public resources for private benefit, and similar to Antrim, not advocating personally this is actually different. If you're advocating for something in your personal capacity, making clear that you're not doing so as a county commissioner. So if you were to speak to the Record Eagle about something that affects your business, making clear that you're not speaking as a county commissioner. That was a requirement that Emmett's includes as well. Emmett's requires a full disclosure if there is an appearance of a conflict of interest, and that's, as in Antrim, a rather broad requiring disclosure so that people and the public is aware that there's a potential issue. As you saw with the 13th Circuit Court cases, though, that doesn't actually affect. If there's an appearance, there still needs to be a recusal, not just a disclosure. The policy says that the person shall not act without the disclosure, but can still vote once that disclosure is made. I don't know why there is the difference, but the Emmett board rules of procedure do actually prohibit voting if the person has a conflict of interest. They actually say that the person shall not vote. However, their code of ethics policy says differently, implies that the person can still vote. So there is a difference there, not for us to decide on what that means. And then enforcement, it has several different steps. There can be a reprimand, loss of committee assignment, restrictions on budget and travel, and then they say removal by the governor. So they are clearly aware of that restriction as well. What the law on that is any member of the public, of the Board of Commissioners, any person can actually refer a matter to the governor for action based on whether somebody, I believe it's civil officer is how it's worded, a civil officer to be removed. So it doesn't require board action, but may be given more weight by the governor if the board actually refers something to the governor. That presents several options. Those examples, you can even go further. As far as the prohibitions, the procedure, and the enforcement, those two policies were rather limited on the procedure they lay out for people if they're going to be sanctioned for a violation of that policy. The prohibitions are different in both. You could do all, none, or some if you want it. And then the procedure, I would encourage you to actually lay out more to provide that fair and just treatment that the Constitution requires. If you looked at the ethics ordinance as well, you'll see how heavy that was on procedure for the protections that somebody's afforded if they're going to be sanctioned. Those two policies that we just looked at don't have that. And then the enforcement, lots of different options if you choose to go there. An ethics ordinance is also a power that this board has, and this is also in 4611, the powers of the County Board of Commissioners. You can pass ordinances that relate to county affairs. And quite clear that the ethical action of elected representatives does relate to county affairs, so long as they don't contravene the general laws of the state. So that's the same as with the policies. The limitations, with an ordinance, you can only set a maximum penalty, and then that maximum penalty is up to a judge to provide, to hash out. It would not include things like reprimanding. It would be a civil infraction with a civil fine or a criminal charge with the potential for up to 90 days in jail and as well a fine. The limitation of that also is that it's purely reactive. If there is an ordinance, it's purely for, if there's a violation, it gets referred to the prosecutor for potential charges. If it's charged, it goes to the courts, where the person has the procedural protections that courts offer. So it's reactive, very limited as far as what the penalties can be, and then those penalties are eventually up to a judge, not up to you. There was one example, a lengthy example that's been given by the Attorney General as a model ordinance. The former Attorney General as a model ordinance. And that lays out several prohibitions. There's another ban on gifts, prohibited gifts, and then also defines what permissible gifts are. Prohibits the disclosure of confidential information, not representing a personal opinion as the board's, not using public resources for private gain, not profiting in private business, a private business deal due to your position on this public board, not using your public position to advance your personal interests, prohibits nepotism, and prohibits a vote under certain limited circumstances. So it goes further. It includes many of the things that Antrim and Emmett did, all as options. And it was clear laying out that you don't have to use this. You could pick and choose from among those if you wanted. Then it lays out gatekeeping options for how, what is the procedure for determining whether somebody violated these prohibitions. It talks about an ethics ombudsperson, talks about an ethics board. Those are all, it does talk about those being situations where they're probably larger counties where there are going to be more issues that need to be sorted through. So in a situation where an ombudsperson or an ethics board is not used, those complaints go to the clerk, which come to the board, and then you can do hearings on it if you choose, or it can be referred to the prosecutor for enforcement on the ordinance. The sanctions that are laid out, criminal or civil, and that's it. There are caps on what you could choose. With criminal, can only be up to 90 days in jail, only up to a $500 fine, and then there's a cap on the civil fine as well. So that does not include reprimand, censure, requests to recuse, requests to resign, formal referral to the governor. None of those would happen with an ordinance. Those are the limitations in the example. It laid out several options. Those can be picked and choose from if that's the route you want to go. As far as what's prohibited, what's the procedure for providing protections, what is the gatekeeping mechanism for any potential complaints. Do they go to the full board? Do they go to an ombudsperson, board of ethics, or straight to the prosecutor? And then the enforcement, the options as well. With the prohibitions, they do have to be specific on what the actual sanction would be. You can't just say it's either criminal or civil if a person accepts a prohibited gift. People need to be provided proper notice, that's a constitutional requirement, of the fine or sanction that they're facing. What you could do, though, is for egregious examples, such as approving a contract without disclosing that you have a personal stake in that contract. You could make that criminal, but then if there was something minimal, such as accepting a prohibited gift, you could say that's a civil fine. So you can pick and choose which would be civil, which would be criminal, but you can't have it be an either thing for any particular prohibition. Oh, the model ordinance that the AG has also has a prohibition on false reports. That could include reckless reports. It could include reckless disregard for the truth. So that ordinance did include a provision on false reports of a conflict of interest, if that was something you wanted to do as well. Those are the options that you have in place with the ethics ordinance and the code of ethics policy. But as a summary, there is currently an aspirational policy in place. It says this is what we want our officials and employees to live up to. Not applicable to you at this point, but it could be. There was a clear issue recently in December that carried over into January, and then you all had to deal with at some point or another. Hopefully it was a learning experience for everybody involved regarding the negative outcomes that can come from simply just not wanting to recuse. And There may be situations that come up where you don't actually think there's a conflict, but due to appearances and due to the backlash, the reputational damage that happened with the last one, that you may choose to actually recuse yourself.
Kit, if we had the Antrim County's ethics policy in place in December,
Okay?
how could that have changed Commissioner Mayer's vote? He still had the opportunity to vote whether that policy was in place or not anyway, I believe.
The chair wasn't going to stop him.
Chair could have said you shouldn't.
Right.
The chair was with him on that vote.
Right.
The kid's saying that he could, though.
Well, it was publicly stated that by a number of commissioners that they didn't feel he should vote. But, you know, I believe it was Kit's opinion, or Chris's opinion, that at that point that he could, or it was Kit's opinion that he technically did have the right to vote. And even though it was suggested that there was a conflict and he should recuse himself, he did still choose to vote.
Any answer would be speculation. So Commissioner Mayer would have had to disclose a potential conflict of interest, which is something that was obvious. Everybody knew that there was an issue, but he never formally stated, you know, this is why, this is what the actual issue is. He never did that. The Antrim policy also requires a statement of belief why you can still be impartial and why a vote would still be in the public interest. That was something that wasn't provided. Not that he couldn't or wouldn't have done that. He may have still done that and said, well, she's the best candidate, so it's in the public interest. Could have said any number of things. The effect would have been that in Antrim, the county chair can order recusal, and I don't know what Chairperson Crawford would have done. I know she ended up voting with him, but I don't know whether she would have looked at the separate issue of whether he should vote. And then that county chair can still be overruled, and so there very well may have been 4 votes to say that, you know, even though people eventually voted with him, there may have been 4 votes to say you shouldn't vote. My advice to him was that nothing prohibited for him from voting. That was the advice to him.
That situation has occurred in the past with other commissioners in other situations too. Tom Mayer wasn't the first.
No, no, certainly not. Nope, as Commissioner Kofia said, and it's about every board, has some issue come up. Before Commissioner Mayer, it was a different commissioner with different issues.
Commissioner Lee.
I've got a question or a comment on all of this. I see the issue that our current code of conduct is rather vague, and I've read some of in the handout from Emmett and in the model, something that goes into real legalese that really is, I find, very confusing to follow. And I go back to what, at the time, Mr. Cooney had said, and I guess this was in reference to the Lathrop issue, and talks about conflict of interest. And I think this is so relevant. The test for disqualification of a public official due to a conflict of interest is fact-sensitive. It depends on whether, under the circumstances, a particular interest had the likely capacity to tempt the official to depart from his or her sworn public duty. At common law, the appearance of impropriety must be something more than a fanciful possibility. So it isn't, there's more to it than just saying there's there's an appearance of a conflict of interest. And I don't know how you try to put this in legalese that we're going to follow, because I think everything can be challenged. I think the reference to the mayor thing is, you said that, I guess you recommended he could vote on it. That was his right. And if I were him, I would have voted. If I read Cooney's definition of a conflict of interest. I don't see anything where he was moving away from his public duty if he felt strongly on his vote. So I have a real problem with this, of trying to nail this down to cover every circumstance. One of the things that they talk about in here, if you're going to do a conflict of interest, in the model they suggest, they say it'll take a year. And they talk about the people that you should get involved in creating a conflict, or not a conflict of interest, rules of order. Not rules of order, but ethics
Ordinance,
policy.
yeah.
So if we're going to take something on, I mean, we have to be aware of the effort it's going to take. I was very concerned when I read through it and talking about, as you just got through mentioning, a board of ethics be formed. And even when they talked about forming a board of ethics, it becomes very partisan, because they say if you're going to have a board of ethics of 3 people, no more than 2 should be from the same political party. So I would hate to see where we get into that mode of making everything very, very political. And the point you made earlier about the majority imposing their will on the minority, if all it takes is a majority of the board to sanction somebody, I don't know if I'd want to be a minority on any board and sign up for this.
Those are real concerns.
Absolute concerns.
The ability to nail down what is an appearance of impropriety or what is a conflict of interest, that would be a Herculean but probably futile task to actually nail that down. Judge Rogers had to leave it as a definition without specific confines. He did give contours. It can't be merely speculative. Has to be based on actual facts, not on remote ties. So there is that. So in some sense, to actually nail down a full definition, not going to happen.
You can't, and in my mind, only a judge is qualified to rule on it. I would not want to have a board take on the powers of a judge and say, okay, we're now interpreting this conflict of interest or the statement, and we're making a finding and ruling on it. Likewise, we formed an ethics committee of citizens taking the position of a judge, because you're guaranteed, if we did something like that, it will end up going into the courts.
Yes. So, like I said, defining the difficult parts precisely may be a futile task. However, there are easy areas. So, like the prohibited gifts versus permissible gifts.
I agree on that.
There are many things that can be done concretely, but not totally.
And I did note a difference between coming up with a full, like former Attorney General Mike Cox is talking about a full ethics ordinance, which is a step beyond tightening up or strengthening our policy, right? Those are two different things. So I appreciate what you're saying, Gordy. We could go down a long road and it could get very, very complex very quickly.
I agree. Certainly the one on the gifts, where they spell out, they give the list of people you receive gifts from, cousins, second cousins, brothers. I mean, you can do that. That's pretty concrete, and a dollar amount. Those things are, if we want to do that, shoot the lock off, that's pretty straightforward and simple, and we can all clearly know what the boundaries are. When you get into conflict of interest, some of the stuff is so vague, and the law is so vague, that I don't know how you would put the onus on the board here to make that determination and say, this is definitely a conflict of interest, therefore you cannot vote on this issue. I think the procedure right now is, you ask legal counsel, do you think this is a conflict of interest? You give the opinion. The person can take the opinion and decide, okay, I agree, I'm not going to vote. If they disagree, they can vote on it right now. And only a judge, if a suit is brought, can make that determination.
That's correct. One more thing I would say. So the last two public or larger scale conflicts of interest could have been solved by a clear line, just not voting on your domestic partner. That would have resolved both of the last two large conflict of interest things, flare-ups. So, but yeah, defining this specifically is probably couldn't happen. For all circumstances, couldn't happen. There was a clear issue recently. Hopefully it's been a learning experience. It did likely, this is an opinion, result in some reputational damage. But it did have a minimal financial impact, just the few hours of my time in responding to the lawsuit. You do have the ability, either a revised ethics policy or an ordinance, to adopt a policy that has some enforcement mechanism with the deterrence effect as well of that enforcement mechanism. The alternatives have numerous options on the prohibitions that can be taken, whether it's just simply the ones that are easy to define, like the gifts, not representing your personal opinions as the opinions of the public board, not using public resources for private gain. Those are all very easy and black and white. But it could go further in defining the more difficult standards, at least for aspirational definition, for this is what we want to live up to, and providing a little bit more guidance than the code right now, and a little bit more than what Judge Rogers' opinions do. So it has the prohibition alternatives, it's got the procedure alternatives, as far as if you want to take the step of an ethics board or an ombudsperson, or conducting hearings if there's an allegation of a conflict of interest violation. And then also have the alternatives on sanctions, whether it's just a censure or reprimand, or something more serious than that. Prohibitions, procedure, sanctions. And state law does provide some limitations, but those are rather scarce. As far as the current steps the legislature has taken, so we couldn't regulate further contracting with the public entity because they have preempted us in that field. Could not further define incompatibility of public office, and could not go further as far as removal or impeachment. That is all I have prepared for you, just so that everything's clear. I have no position on this. It's entirely your choice, and I'm here to help if you have questions or eventually a proposal.
Hey, Kit, can you email us your presentation?
Sure.
Thanks.
It'll be out on the website for everybody.
Oh, okay.
Yeah, attached to the packet.
Kid, I think,
Oh,
at
I
least from
understand.
my perspective, I'm not interested in the Mike Cox thing. It's way too wordy, way too detailed. There's more red tape in that than we have staff enough to take care of. I think probably would be appropriate for us to look at some of those prohibitions, if you will. I think we can clean up our policy not only as it affects boards and commissions, but as it affects county employees. I think there's some of those gray areas in there the prohibitions could be taken care of. Whether we want to include, we have a nepotism policy in some of our departments, whether we want to put that in is it in all of our departments, Nate? But, we've had that discussion on a few occasions too. Maybe some of that can be reflected in that ethics policy as one of those prohibitions, whether we do that or not. I think we can clean that up, but I think the key piece of that, no matter what we do with the ethics policy, is if this board wants to hold themselves accountable to that policy. Because as I understand it, we are not at this point held to that policy. I like the idea of putting in some prohibitions, some cleaning up things, because I think our current ethics policy is very, very very, very vague. I like the opinions of Bob Cooney pretty well, to meet where we need to be. I certainly don't think we need to go down the road with the Mike Cox type thing. That's just way too much red tape for me. I struggle with red tape in the first place. So, but I believe that we could look at some prohibitions at our ethics policy. I think that would be good for all county employees and all county departments. But that's a fine discussion to have. But one of the discussions we as a group have to have is whether or not we are going to hold ourselves to that policy that we hold the rest of the county employees to.
And that would have to be, Antrim's, maybe as you looked through it, they specifically, they put themselves in specifically county commissioners, they name themselves, they speak to how it affects them directly as opposed to employees, which of course there's a different process in place for employees where termination is an option, yeah. So I agree, I think the Cox thing is interesting, he made some good points, but that is a pretty extensive piece, and I will say I'm not necessarily in the mind of like creating a whole ombudsman and an ordinance. I'm looking at a policy that we currently have that does not appear to really even affect county commissioners. I'm also looking at things like, Leelanau, Antrim, Emmett, where they have a training. I think it could be built into our board rules. Similarly, we had a FOIA training as part of orientation that could be built in so that we're able to kind of proactively look at this and think it through and understand it and ask our questions. Maybe it's a presentation similar, Kit, to what you just did for each new term, a signature of understanding, and then possibly some, I was looking actually, a couple of our townships, Peninsula, Garfield, Long Lake, and East Bay at least, have a standing agenda item where they ask members of the board to disclose any conflict of interest. It's just built into the culture to say, we're going to think about this, we're going to check ourselves at each meeting, and keep that as part of the conversation. So as the policy currently reads, I feel like it's very weak, and there are things that we could do to tighten it up and hold ourselves accountable and value public trust without going down this incredibly lengthy, red tape laden path of a full ordinance. So I think there might be some sort of a happy medium, but I certainly think the current one is weak at best and vague and doesn't apply to us, and that feels like a problem to me. So
if we had a policy like that, how would you deal with a commissioner that refused to sign it?
That refuse to even sign the agreement that they will hold themselves to it?
Yeah, because we don't have, to my knowledge, any legal mechanism to compel someone to sign something because the people elect. The board can't take away what the people gave, at least in my view.
Sure. It's still, it's a marker for me as a voter. Like, again, recently crossing the line from a voter and a concerned citizen, wanting my board to be ethical and to hold itself to high standards to the other side of the table. I think that's us providing a mechanism where the voters can say, why did this person, what's the problem with having to sign that you're going to hold yourself to this? We've created a mechanism that is now in place where nothing currently exists. And so I think that's important. It's a good question.
Yeah, and so if the voters are the mechanism, then why have the policy? Because District 2 is a great example. If you look back, Commissioner Maxbauer held that seat. The voters were unhappy with her performance, publicly did some things that damaged the public trust. We had Tom Mayer the next term.
Yeah. Right. And in the meantime, we had 2 years of the public feeling not so great about the decisions of this board. And I don't like the idea that we sort of sit there and have no mechanisms in place to say, look, you're making a decision that the board, the plurality of the board feels is in conflict, and we have some steps that we can actually take that are written into an ordinance, not an ordinance, into our policy so that we're not just reacting. We're saying, okay, this is a situation, here are some steps that the board could agree to take to let the public know that we appreciate that this is a problem, as opposed to just waiting 2 years for the next election. I think that it reflects poorly on the whole board if we do nothing, except say mean things about each other in the paper,
When you look at our current policy, I agree, it's only 2 or 3 pages long, which is in some cases great. But I think it covers, my take is it covers all of the things that these other, all of the headings, all the issues that these other policies cover. It just isn't as complete or as defined. For example, it mentions gifts, but doesn't go into any detail. Like the other ones, like I said, go into who specifically you can receive gifts from, and it's not an issue.
Right.
They have dollar amounts. So are we proposing to pretty much take what we currently have, expand it to make it more inclusive or definable, ask the, all of the elected officials, including judges, sheriff, everybody, and commissioners alike, to request that they sign it. Is that where we're at? Or is there something else that's missing in total in our policy?
I mean, I think that it's both looking at the fact that it's pretty broad and vague right now. It doesn't go into enough, to me,
Detail.
satisfactory detail. It's not specific to commissioners, which I think needs to be remedied. And then on the other side, again, to the board having some tools to try to build, retain, repair public trust when there has been a breach. I want to see some tools on the other side for the commission as a whole to say, you know, maybe it is a reprimand. Maybe it is something.
So you're saying a majority of the board, if 4 members
It could be a
wanted to-
two-thirds majority. We could
okay, or
try to
some,
address.
whatever, wanted to be judge and jury on something and reprimand you.
We are legislators. I mean, this is part of our job.
I have an issue with that, but in looking at the, it covers confidential, all of the issues I think get talked about, they're mentioned here. I agree they can be expanded upon. Is there anything that you want to add as a topic? I mean, it's got confidential information, personal business, gifts and favors, use of personal property.
There was one thing in, even though, like I said, I don't think going down former AG Mike Cox's road of a whole ordinance. He did reference something that I think comes up, you know, the question for the citizenry with public bodies is, do you have a financial interest? So there could be a requirement built in. If you look at page 9 of the model ethics ordinance, there's an annual disclosure statement of disclosing financial interests. And that's something we could at least look at. I wanted to start and just have the conversation and dig into this and get legal counsel to walk us through it, so it's not just my layperson's opinion or reading. And then I would hope maybe we could have a working group of some sort to dig into this a little deeper, ask some of these good and hard questions about the pros and cons of, are we becoming too restrictive, are we becoming too punitive, or, you know, where's that balance? Rather than me coming today and saying, here's what I think we should do, I think we need to look at this. I think we need to think carefully and look at some examples where it looks like some other counties have done
Yeah,
maybe better job.
I would not have an issue with expanding on and better defining these points. But if there's something you want to bring in, like all elected officials prior have to give their full financial disclosure, that's, you're adding a whole nother topic.
I think it's pretty related, actually, because a lot of the financial conflict of interest has to do with your financial interests, and finding out about it incidentally is not as proactive as us all saying, well, here are my financial interests, and signing some sort of annual disclosure. I'm not saying I think we should do this. I'm saying I think we should look at this.
Okay.
I think we need to look into it because the current policy feels very lacking.
And you're also in support of some means of somebody deciding that if the feeling is that they're not in compliance, that there is some form of reprimand made by somebody.
Potentially, yeah. And I'm not committing right now to whether that absolutely has to be the board.
Yeah, that one, it does make sense. I believe you shouldn't have a law or a policy without a means of enforcing it. It's just
Exactly.
foolish.
Yeah.
And I've made that
Tiger.
comment as a trustee when we used to do that in Acton. But that's really a slippery slope.
Be very thoughtful.
Because the options are, you have the board do it, and it can become political.
Yeah.
As the
Yeah, it
warning
has to.
is. If you appoint an ethics committee, same thing, and they even spelled out, it better be people from different parties. So I think it's interesting discussion, and if somebody has a moderate way of doing that, that isn't full of traps.
Right.
It'd be an interesting topic, but nothing I saw in here of in the handout I felt comfortable with in terms of compliance. So if there's
I'm looking at this from just my own point of view, and having a construction company where we pull plenty of building permits. We go to the health department. We pull plenty of water and sewer permits, well and septic permits. We get driveway permits from the road commission. Well, should I be recusing myself from appointing a road commission member? Because, they're in charge of my permits,
Right.
I go to environmental health. We make, just a couple weeks ago, we refused the purchase of a animal control vehicle. I get permits from them. I have, with construction code, building permits. Is Bruce giving me is he easing up on my inspections? Is he, giving me an easier way to go?
Or a harder way.
Or a harder way, I think everybody's been fair. Nothing's changed since I've been in here. Animal control, I've got a dog. We voted on policy, or the pricing for the licenses. At what point do I step down from casting a vote?
Right.
I've not stepped down from any of these.
Right.
How far do you take it?
Right. It's a very reasonable question, and again, why I feel like maybe a working group, an ad hoc of some sort to dig into that stuff. I don't know that we're gonna resolve it today, but I
Right.
think it's a
Right.
worthwhile conversation and a very fair question.
I mean, just as one of the new guys, I felt like I was like stepping into that, in my first and second meetings as well. And I guess if we do go forward with trying to figure this out in some greater detail, that the things I would like are, the better definitions on the prohibitions, just so I have some clarity of these are the specific kinds of things. Like if they're not listed, then there might still be problems, but they're obviously getting into gray zones, or at least like shrinking the gray zone. And I know whether or not I can do these things, just so to give me more clarity. And then on the enforcement side, like I totally hear Commissioner LaPointe's point, and I agree. I was thinking of this last night. Like you can create this thing and use it as like a club to beat your opponents over the head. Everything's a conflict of interest, and you don't want it that either. But I've also like not here, but in the wide world, I have seen people in government and out of government who are of the personality that they will push and push and push and do until you physically stop them, right? And so some kind of means of, putting some kind of halt on the most egregious actions of like, these are clearly conflicts of interest, and like there's nothing we can even do about it. So clarity, protecting so that it's not just beating, free-for-all, beating everybody over the head, and then stopping the worst abuses. I don't know. That's what I would want out of it. I kind of liked a lot of the pieces of the Antrim. One of the things that worried me about that was in all of the definitions of the prohibitions, it was direct or indirect, personal or financial, and I was like, I got to thinking, well, if I'm making
everything.
a vote on some kind of thing that in my mind, I choose to live in the city because I choose to like more urban setting than rural settings, and just if I'm voting on something that improves, in my mind is more urban, but it has the indirect impact maybe of improving my land value, then I've got to, because it's benefiting the city. Maybe it's just something that's generally benefiting the city, but now it's indirectly benefiting me because it's improving my, then all of a sudden it's a conflict of interest. I don't want to go down that path either, but I don't know. I don't think it's all settled today, but
Let's take,
I just wanted to add something in terms of an observation. It's not only whether or not you enhance the existing policy or create a new policy and the enforcement of that policy. You have to come up with a procedure to protect the rights of the commissioner that's being accused.
Right.
As an example, the Sheriff's Department has a code of ethics policy that's 1 page. We're very comfortable in what it says. We're very comfortable in taking enforcement action for violations. We have a 15 or 12-page document that dictates how we investigate complaints to make sure that the procedural due process of that employee or elected official is protected. Who's going to do it? How is it going to be done? How are you going to handle complaints from fellow commissioners, from employees, or from the public? Those processes need to be defined as well. Kit, I think, or Chris can share some exposure to the recent Emmett County policy and some of the troubles they had determining a process. But like I said, we have a maintenance of standard policy at the Sheriff's Office that dictates how we investigate these things. It's longer than the policy itself. So that has to be considered as well.
If you get the chance, read the February 24th Petoskey News article on Emmett County. Basically, you'll read how that policy came in play, and the long and the short of it was that there was a hearing, there was alleged ethics violations, and at the end of that 4.5-hour hearing, their commission decided to take no action.
They did declare that there was a violation,
They
though,
declared
so
there
that's
was a
an action.
violation, but took absolutely no action. My former life as a city attorney, where cities have more power to have charter provisions dealing with ethics, I've dealt with similar issues. I dealt with a very contentious issue involving a city council member where there was hours and hours of hearings, there was lawsuits, and at the end of the day, that council member is still has a seat as far as I know. So this is a very good discussion. There certainly are areas where we can improve, but you also have to understand the mechanics of it. And the real life examples are, you may set her up so that you have a commissioner who is complaining about another commissioner who went and talked to staff or was rude to a citizen during citizen comment, which is what I dealt with in Allen Park. You know, how far the rabbit hole do you want to go ultimately is the question you have to ask yourself.
Well, I think we were talking about the possibility of a committee or someone to just take a look at our existing policy, expand upon it, clarify some of the points, and then if it's, hopefully have something approved by the board, and then request every elected official to assign it. I mean, I can support that.
I think, I certainly agree with the idea that our policy can use some embellishment, if you will. I think some of those definitions, particularly in the prohibitions and what's acceptable and what's not, I think that's absolutely appropriate. That applies to all county employees and all elected officials except this board. So if this board wants to hold themselves to that standard, that's going to be a separate action. I think we can amend the ethics policy, but as I've read the whole, what I've read, the ethics policy technically does not apply to us. Is that correct, Kit?
Currently, absolutely.
But we
That's
could
absolutely
amend
correct,
it.
yeah.
We absolutely could, but what I'm saying is, I think there's two separate issues. One is whether or not our ethics policy is appropriate, whether it's properly defined. And the second issue is whether or not this county board of commissioners wants to hold themselves to that policy.
Those are separate issues, yes.
I think they're two separate issues. And I think it's easy to say we need to go through and define the ethics policy, but it's kind of mute to do that unless it is our belief that the Board of Commissioners should be held to that policy.
I certainly intended, when I suggested some sort of a working group to look at this, my thought was holding ourselves accountable and refashioning it in such a way that that is clearly spelled out, as opposed to how it currently reads, which doesn't apply to us. So yes, from my perspective, I don't want to speak for
The statement in here, any employee or official, aren't we officials? We fall under that category, right?
The language that it used, it appears, was intended to apply
To us.
to commissioners, and officials is obviously broader than just commissioners.
Okay.
Prosecutor, sheriff,
Right.
clerk. But the effect of it is that it's not applicable.
It's not applicable by state law, unless we adopt the ordinance to say that it is.
So we have to have an ordinance on?
No.
To make it
Policy.
applicable to
A
us?
resolution or if you sign it.
Okay, a resolution or we sign, okay, simple, not an ordinance.
And in practice, who holds you to that standard?
Right.
Who's going to hold you?
And that's a whole other, that's
Correct.
like on that other side, who's responsible? Are we?
You know, and I think the thing is, no matter what we do, you know, we can as a group or as individuals say, Gordy, you should not vote on this issue because it's in Acme Township's adjacent property. But the fact is, there's no legal grounds by which for me to preclude him from voting. Now, if he votes, the results of that can be determined by
The judge.
the circuit court.
Right.
You know, but this board, you know, I'm not sure that there's any point that this board should have jurisdiction over saying, yes, you can vote, no, you can't vote.
I agree.
The
How does that
effect of
apply
your
with
vote.
what we just did with basically nullifying?
Right.
We just did. We
Terminology-
just set a really high bar.
Terminology is important.
Okay.
And what the resolution was that we are not giving effect to Commissioner Mayor's vote. So we, in our opinion, it was an invalid vote. So it wasn't saying we are subtracting Commissioner Mayor's vote. It's saying we believe that it wasn't valid.
Had no effect.
So I don't know if I explained it well, but it was kind of a challenge, I guess, just saying we don't believe it had effect and we're going to treat it as if it was ineffective.
And that, yeah, that's an
The
action.
judge
that
never
this-
ruled on that.
Right.
Correct.
So you don't,
But there was a real world effect to that where, right, like we had to then redo the process in a way, at least the appointment. And had we not taken that step of reappointing her, there would have been an effect. This board took a concrete action that essentially nullified the vote of the last board. And had we not had the amendment and
I guess
reappointed her,
I'm just
right? So-
uncomfortable, and I'll push back a little bit on saying that you nullified it.
Okay.
I think the better terminology would be saying we moved forward as if there had never been a valid vote.
We ignored it.
Yeah.
And redid it. Okay. Anyway, I guess my point is in the real world, there was an action that this new board took that impacted the
we
last
didn't
board's
nullify that
decision.
vote, we just voted over that vote and gave it the
That's
same
right, yeah.
vote.
Yes,
I mean, so.
that is
You didn't
That was the
nullify
effect.
the vote.
correct.
Okay,
Just
so it's.
acted
that
as if
vote
it
is
never
still
happened.
stands.
And the action had taken place with the prior board. I mean, you had, it came to this new board because it was, the vote was nullified or it wasn't accepted.
It came to this
And-
board on the motion to reconsider or rescind.
Right. So this board just acted on,
That was kind of
on the previous.
messed up deal.
It didn't come to this board where we wanted to rescind it, or, I guess it did at the first meeting.
That's how it originally
Right.
came, but then the resolution that was passed,
Right.
the motion that was passed was different than rescinding.
Right, okay.
So not to get too down in the weeds on that, I appreciated the time that you took, Kit, to lay this out for us. This is, I found very helpful, and, you know, my thought is, it's worth looking at what we currently have and trying to improve it, and what that ends up looking like is something that maybe, well, we would all have to decide, right? So,
Okay. Are we ready for second public comment?
Sure.
sure.
Would anyone like to make a public comment?
I guess the question is, do we have any direction for staff that they want us to move forward with anything right now?
So-
or
I mean, I
do
was
we
treating
wanna-
a study session
No,
as
I'm
not
assuming
someplace-
we're gonna have this discussion again. If so, is there something we want staff to prepare
So,
for us before we have that
To,
discussion?
if you
This
wish
is
to
a
move
study
forward,
session.
seeing as this board decided we are not taking any actions at study sessions.
Right.
It requires board action to form an ad hoc committee.
Right.
So you would
So I
bring it
didn't
to the
intend
next
to
board
request
meeting
that,
a
right.
week from today.
Okay. I was just curious if we were going to ask staff to do anything prior to taking that action, or do we wait until we take that action?
I'm fine to wait until
I'm
we're
comfortable with
able
what
to
we've
take
done so
action.
far.
I am too.
Okay. Second public comment. Please jump right up there if you've got something to share with us. Right ahead.
John Dispelder,
Thanks, John.
collegial, focused, positive, thank you.
Okay. Anyone else for public comment? Jump up there, give us your name and where you're from.
Linda Pepper, 4306 Central Park Drive, Ground. And thank you very much for this. It was very illuminating. One question that I still have, Betsy brought it up, and I did a little research and couldn't find an answer. Are you to be representing everybody in the county, or are you to be representing only the people in your district? And are you supposed to listen to everybody in the county, or are you only supposed to represent or listen to the people from your district? That was something that I would really like clarified, because it affects all of us when you make decisions. I did look it up. I looked for Attorney General's permission or opinions on that, and I couldn't find anything on it. So if you're going to address this, if you're going to have a working group, that would be a question that I think a lot of us would like to know. Thank you.
Thank you. Anyone else for public comment?
Hello, Dave Petro, Interlochen. Sorry I got here late. It was a little strange between here and there. Some things that I've going through this stuff, I don't know, I would like to see, and that's one of the things a board writing their own rules for conflict of interest over themselves is almost a conflict of interest in its, in the action. It would be nice to have more public writing the rules type thing, so that that you're responsible to us. One of the things that it comes up in there, one of those other, I think it was Antrim or one of them else, has a big long list of those who are to be reported as being given a conflict to your decision or something like, not just the immediate household spouse or something like that. We have issues that come up in this county here that it may be a relative who, if we do some sale or buying of land or something like that, may benefit somebody's close family, let's put it that way, beyond themselves and things like that. I think that would be a conflict of interest. But if by your own rules, it would not be presented. By Antrim counties, it would have to be disclosed. I think possibly if you have things like if someone has a conflict of interest and before you vote on something, maybe we should at least make sure that that person votes first. Okay, so that it might say, well, I think that person has a conflict and I will change my vote. I was going to vote yes, but now I'll vote no. Or I was going to vote no, now I'll vote yes. So that it would give you an opportunity to express your belief that there was a conflict. And the other thing is that this keeps coming up about the Tom Mayer thing and things like that. And one of the basics of all of this conflict of interest goes into the financial part of it. There's some financial gain. In this Tom Mayer thing, there was nobody making any money. So it all fell back not to financial gain, but to political preferences. That was wrong to call that a conflict, and I still think it was wrong. So thank you.
Anyone else for public comment? Seeing none, we're at the end of our agenda. We stand adjourned.
Brad, 9:50.
Gordy.